Greetings, legal enthusiasts. Welcome back to our channel, where we unravel the intricacies of legal concepts. Today, we're delving into the legal realm to differentiate between two crucial terms, pledge and hypothecation. Pledge and hypothecation are both ways of securing a loan or credit. They're used by lenders to protect themselves in case the borrower defaults on the loan. But what's the difference between the two? That's what we'll explore in this presentation. Definition of pledge. A pledge is a type of security interest that is created when a borrower pledges collateral to a lender as a guarantee for a loan. The collateral can be any asset that has value, such as real estate, stocks, or bonds. If the borrower defaults on the loan, the lender has the right to take possession of the collateral and sell it to recover their losses. Law. The Indian Contract Act, 1872, Section 172, 176. Pledge refers to the transfer of possession of goods or assets by a borrower, pledger, to the lender, pledgee, as security for a loan or debt. The possession remains with the lender until the debt is repaid. Pledging in financial terms. In financial terms, pledging is a way for lenders to mitigate risk by securing their loans with collateral. This means that if the borrower defaults on the loan, the lender can seize the collateral to recover their losses. Pledging also provides borrowers with access to financing that they may not otherwise be able to obtain. For example, if a borrower wants to buy a house but does not have enough money for a down payment, they may be able to pledge another property as collateral to secure a mortgage or, pledging jewelry with a pawnbroker for a loan. Definition of hypothecation. Hypothecation is a term used in finance to describe the process of pledging an asset as collateral for a loan, without actually transferring ownership of the asset. This means that the borrower retains ownership of the asset, but the lender has the right to seize it if the borrower defaults on the loan. Hypothecation involves the creation of a charge against movable assets as collateral for a loan, without transferring possession. The borrower, hypothecator, retains possession and can continue using the assets, subject to certain terms. Laws. The Companies Act, 2013, for Companies, Section 2, 31. The Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, 2002, for Banks and Financial Institutions, Section 2, 1, c. One common example of hypothecation is when someone takes out a mortgage to buy a house. The house serves as collateral for the loan, but the borrower still owns the house and can continue to live in it as long as they make their mortgage payments on time. Key differences. Pledge involves the transfer of possession of an asset to the lender as collateral for a loan, while hypothecation involves giving the lender a right over the asset without transferring its possession. In pledge, the lender has the right to sell the asset in case of default, while in hypothecation, the lender can only take legal action to recover the loan amount. In pledge, borrower cannot use the pledged asset until the debt is repaid and the possession is returned, while in hypothecation the borrower can continue to use the hypothecated asset for business operations, subject to the terms of the agreement. Legal requirements for pledge and hypothecation of movable assets. Pledge of movable assets does not require registration under the Companies Act, 2013. Hypothecation of movable assets requires registration under the Companies Act, 2013. Formal agreement. A pledge requires a formal agreement outlining the terms and conditions of the pledge. The formal agreement for a pledge should include the right to sell the asset in case of default. Hypothecation also requires a formal agreement outlining the terms, but the lender's rights and recourse might be more complex due to possession remaining with the borrower. Advantages and disadvantages. Pledge and hypothecation are both widely used in finance, but they have different advantages and disadvantages. One advantage of pledge is that it provides a higher level of security for the lender, as they have direct control over the collateral. However, this also means that the borrower has less flexibility in using the collateral for other purposes. On the other hand, hypothecation allows the borrower to continue using the collateral while also providing some level of security for the lender. However, this also means that the lender has less control over the collateral and may not be able to recover the full amount owed if the borrower defaults. Conclusion. In summary, pledge and hypothecation are both important concepts in contract and finance. Pledge involves the transfer of ownership of an asset to a lender as collateral for a loan, while hypothecation involves the creation of a charge over an asset without transferring ownership. It is important to understand the differences between the two because they can have different legal implications and affect the priority of creditors in case of default. While both pledge and hypothecation have their advantages and disadvantages, it ultimately depends on the specific situation and needs of the borrower. There you have it, the legal distinctions between pledge and hypothecation. If this legal breakdown was enlightening, don't hesitate to hit the like button, subscribe to our channel, share this video with your fellow legal enthusiasts, and leave your thoughts in the comments section below. Until next time, stay legally informed. Thank you for tuning in.